Okay, so in its decision, Clapper v. Amnesty International of the 26th February 2013, the United States Supreme Court shows an example of lack of standing. In this case, the association Amnesty International tries to challenge the Foreign Intelligence Surveillance Act of 1974, amended by the Amendments Act of 2008. The Attorney General and the Director of National Intelligence, Mr. James Clapper, must obtain the Foreign Intelligence Surveillance Court's approval in order to set surveillance on people who are not U.S. persons and are reasonably believed to be located outside the United States thanks to this act. This FISA Amendments Act allows a federal court to authorize surveillance on agents without proving their potential work for a foreign power. Indeed, the government only needs to show that the agent is not a US person and seeks foreign intelligence information, as we just said. Therefore, Amnesty International argued that this very low standard of proof required to obtain such surveillance is critical. Due to Amnesty International's point of view, if US persons cannot be targeted thanks to this act, it means that only their foreign contacts will be targeted. In order to avoid this situation, agents will have to take costly and burdensome measures to protect the confidentiality of their communications. We must ask ourselves this question: does an action brought to contest an amendment which allows a federal administration to deliver authorization for surveillance on foreign agents is sufficiently concrete, particularized, and actual or imminent on the ground of standing? The USSC decided to dismiss the case on the ground of standing. The Chief Justice was John Roberts, who joined the majority formed by Justice Alito, who delivered the opinion of the court. On the one hand, Justices Scalia, Kennedy, and Thomas also joined the majority. On the other hand, Justice Breyer filed a dissenting opinion joined by Justices Ginsburg, Sotomayor, and Kagan. The justices remind us that all plaintiffs must establish standing on the ground of Article 3 of the United States Constitution in order to file a suit. The USSC considers that the action brought by Amnesty International rests on a speculative chain of possibilities that does not establish that their potential injury is certainly impending or is fairly traceable. Justices said that the fact that the government will imminently target communications to which respondents are parties is not an injury because the FISA Amendments Act does not allow to target US persons such as Amnesty International. The USSC said that the association has no actual knowledge of the governmental's targeting practices. Therefore, the association lacks of standing. Moreover, justices had that even if the government wants to use surveillance against these agents, it has many other ways to do so, and all these ways are not contested by Amnesty International. Justices also argued that the rise of the cost to protect the confidentiality of their communications is just a product of their fear of surveillance, which is insufficient to create standing. However, it must be said that Justice Stephen Breyer, who had a dissenting opinion, argued that the harm the warrantless wiretapping law was causing is not merely speculative. Indeed, he said that the government will intercept at least some electronic communication to which at least some of the plaintiffs are parties, such as Amnesty International. As a conclusion, the HuffPost wrote that the Supreme Court has set a high bar for civil libertarians hoping to prove that they are being harmed. However, we must say that this decision was taken in order to fight against terrorism and more specifically against Al-Qaeda, and to let the US government to seek terrorists.